participants. So I'm looking at my participant right now. I think we have about 19,
Okay.
which is a good number
Right.
to start. So uh, without further delay, I'll first of all introduce myself. To those of you that don't know me, uh, my name is Sek Aniekpon. Don't bother to ask me the last name because even me myself, I end up seeing myself being called that last name. There's a way I pronounce it, but it's okay. You just take it the way it is. Sek Aniekpon, and I'll be your host for today. Um, so I want to welcome every one of us to this another great time. I like to call this section a learning section. To all of us that have been part of this running, part of this progress, we all know that it's always a good time to learn whenever we come together as a family and we decide to title ourselves as Nigerians in West Texas. So we are a family here, as a matter of fact, a newborn family in West Texas, and we are growing. If you want to know, we are growing. I want to thank the um, the organizers of this great section. I mean, kudos to them, applause to them. They've done great things. They've done, in fact, beyond our expectation here in West Texas. It happens to be the first of its kind. We've never had a group like this before. From what I understand, from what I know, this is the very first of its kind. I want to thank all the people that have put so much work to make this a success. And I want to thank you so much, and your efforts uh, would always be appreciated. Thank you so much. Thank you so much. And also, I want us to understand that this section will be running this section for about an hour. And if you have your questions, you have your comments, please just take advantage of the options we have on our Zoom. I think we have option where we have the chats forum where you can drop your message, or you have a comment to share, you have something to talk about, please. I will be looking at the chat in short periodically. I'll be looking at it to make sure we're not missing any chats or questions. So I want to assure you that your questions will be dealt with, whatever concerns you have. And to be very specific, this is very, very important to note. Our speaker would not be attending to any other questions that is not immigration related questions. So it has to be immigration questions based on our topic. Our topic today, we're going to be talking about recent changes, or she's going to be talking about recent changes in our U.S. immigration's law. By the time you go with her, listen attentively during that session, you may have one or two questions to ask. And also, another topic is pathways to obtain a green card. I know that's a very important topic that every one of us will want to be part of. So, please, without further ado, let me introduce our speaker to us today. We are very blessed. We are very fortunate to have a professional amongst us. Uh, I'll go by her name first. She is called Attorney Raheemat Aderibigbe. And she's going to forgive me if I did not pronounce the last name well.
You actually did well.
I tried as much as I can to get that last name. As a matter of fact, I had a tutorial class with my wife just to put me through, so I don't have to make any mistakes.
You
So
actually didn't. You did well. You did well. I'm proud.
thank you so much. So she is known and she wish to be addressed as Attorney Raheemat Aderibigbe. And attorney is a U.S. immigration lawyer, attorney, and a New York divorce lawyer. So she's got it all. She's got it all. Whatever questions you have, feel free to send your questions, comments down there on our chat section. I'll be able to look into it and pass it across to her to deal with those questions. So I would now hand over to our speaker. So please, if you have your Zoom on, if you don't mind, please continue to mute. I see everyone is complying. I so much love this. Everybody has complied. Please mute your mic, and we don't have to see your face. If you don't want to show us your face, that's fine. But just help us to mute your mic so that we don't have any interference on the background. So thank you so much, everyone, for being here. And I hand over to our speaker for the day. Over to you, ma'am.
Hi, good afternoon, everyone. As the host, I don't want to butcher your name too. So, as the host already stated, my name is Raheemat Aderibigbe. Although I am not part of the Nigerians in West Texas because I'm a New York resident, I am happy doing this for you guys. And my office is located in Staten Island, New York, but I represent people in all 50 states. So, yes, I can represent you regardless of where you live in the United States. Now, as you already stated, I am going to be talking about US immigration's law, the policy changes and ways to obtain green cards, and, a little bit of more information as we go along. Now, one thing I wouldn't be talking about is any case specific question like, oh, my case is this, my case is that. What do you think? Due to confidentiality reasons, I cannot answer certain case specific questions, but feel free to email me. My email is there, or feel free to call my office and we can schedule a proper consultation to address those concerns regarding your case. And also, I wouldn't be talking a lot about employment based immigration because that's an entirely different realm. And I assume that a lot of people on this platform have been in the country for at least 1 year, probably overstayed their visa or, have some kind of case pending. Just want to get information. So although I will talk about one or two things about employment based, but that's not going to be the main focus of my clinic today. This is titled Immigration 2.0 because we're under the second administration, and it's very important that, we address certain things. I don't know if you guys, are you all able to see my screen? Because sir, can you see my screen?
Yes.
Okay, good. So as many of us may already know that there are different ways to obtain a green card in the United States. And the most famous one is through the family-based, which is being a spouse of a US citizen or a parent of a US citizen or an unmarried child under 21 of a US citizen. And this category will be categorized as the immediate relatives. So for this, if you are an immediate relative, it doesn't matter whether you've overstayed your visa. It doesn't matter whether you've worked without authorization. Those are automatically forgiven as an immediate relative. There's also the preference category under the family-based law, and this is when you're a spouse of a green card holder, you're married child of a U.S. citizen, you're an adult child of a U.S. citizen, or a green card holder. For that, there are a lot of hurdles that need to be crossed. And if you have overstayed your visa, you cannot obtain a green card in the United States without needing a waiver if you fall under the preference category. And that requires an extensive consultation. So if you're married to a green card holder and you've overstayed your visa, it's very important that you schedule a consultation with an attorney so that the attorney can guide you and properly advise you if you're able to obtain a green card through that pathway. We also know that under the family base, there's the VAWA category, which I'm sure a lot of people are aware of. If you've been a victim of abuse in your marriage, or you are being abused by your child who is a citizen and over 21, you can apply for VAWA as a victim of abuse. Even if you are a minor child and have been abused by U.S. citizen parents, you can apply for VAWA. So VAWA is not only limited to being a spouse of a U.S. citizen. You can apply for VAWA if you're a parent or a child of a U.S. citizen who has been abused. Um, and if you entered legally into the country, so that you were paroled into the country, or you had a visa when you entered the country and overstayed, you are also eligible to adjust status while you apply for VAWA. So you can file that application concurrently. And that's also for being a spouse of a deceased U.S. citizen. As long as this application are filed within 2 years of the divorce, if you're filing for VAWA, you have to file the VAWA application within 2 years of divorce. So let's say you got divorced January 1st of 2024, you must put in your VAWA application on or before January 1st of 2026. So you have that 2-year time frame to apply, regardless of whether you're still together with a U.S. citizen spouse or not. But for parents and children, but for children, there's a cap. You have to apply before you turn 25 and be unmarried. But for parents, you can apply anytime. And then for the widow as well, you have to apply within 2 years of the passing away of your U.S. citizen spouse. So after 2 years, you cannot apply under the widow petition. Another way to obtain a green card in the U.S. is through the humanitarian grounds. There's something called the special immigrant juvenile status. And these relief are for people that are under 21, unmarried, are being abandoned or neglected by one or both of their parents. And they also have to show that reunification with that parent is not viable, meaning that you're claiming that your father abandoned you, neglected you, you don't have any relationship. You have to prove that reunification is not possible. It's not like tomorrow you guys can sort things out and say, hey, you know what, you're my father again, I forgive you, things like that. Although there are times where people are reunified with their parents, but at the time when you're applying for siege, you have to show that reunification is impossible. And then you must also show that returning to your own country, in this case, let's say Nigeria, is not or would not be in your best interest. I don't have anything left. If I go back to Nigeria, my father is not going to care for me, or my mother is not going to care for me. I don't have any relatives that would care for me. It doesn't have to necessarily be that your life would be in danger. For that siege category, there are 2 steps to that. And the first step is the family court. And this is based on state law. So if you're in Texas or New York, you have to hire a family court attorney that handles siege in the state where the child lives. After the process is done, then you apply for the immigration part. Please mute your microphone. And then you apply for the immigration part. And the good thing about siege is that for the family part, one of the parents can actually be the guardian because you need guardianship. So you can show that the father abandoned the child and the mother is the guardian. It doesn't require both parents to abandon or neglect the child. It just requires that at least one of the parents. And that's the good thing about the siege process. However, the downside to that is if that child eventually becomes a citizen through siege pathway, that child cannot petition for either parents. regardless of whether that other parent abused or abandoned him or not. So as the mother, as the mother or father, if you're undocumented, you're going to have to look for another way to obtain your green card because that child cannot petition for you. Any child that obtains a status through siege cannot petition for either of the parents. That's the law. Now we have the U visa, which this is a visa category for people who have been a victim of a specific crime. It could be robbery, it could be domestic violence, it could be abduction. There are certain crimes that are listed under the U visa qualifying category. And for example, for DV, domestic violence, you don't have to be married to the person. It could be just your partner. It could be a roommate. It could be a friend, you guys living together. The most important requirement for U visa is that there has to be some sort of police intervention. So, for example, if your employer abused you and assaulted you at work and you call the police, and the police, there's a police report, you filed some charges, regardless of whether that person is charged, as long as you're also willing to assist the police with any questioning, you're available, you can apply for a U visa. And that's a pathway to obtaining a green card. Although, unlike adjustment of status under the family base, you have to wait. There's something called the visa bulletin, the priority date. You have to wait couple of years. So this is not something you can obtain within a year or two. It could take at least 5 years, but at least it leads to getting a green card eventually. Same as the T visa. T visa is very specific to trafficking. You have to demonstrate that you've been trafficked. It could be sexual trafficking or labor trafficking. Somebody promised you to come to the US. Oh, we're going to give you a job. We're going to do this. We're going to do that. And then you enter the US and the story changed and they're making you work what? 100 hours a week. I don't know if that's possible, but like 80 hours a week and not paying you what you agreed on. That falls under labor trafficking. And there's certain things you have to report the person and things like that. Eventually, you can get a green card through this part. And also, if you've been sexually trafficked into the US, you can apply for a T visa. A lot of people are familiar with asylum. The requirement for asylum is very clear. You must demonstrate that you are afraid to return back to your own country. It's not necessarily that you've suffered any kind of past persecution, but you must show that you would also suffer a well-founded fear of future persecution. And you are afraid to go back. The government of that country is unable and unwilling to protect you from this danger. A lot of people, which before I know a lot of people just apply for asylum because they want to get a work authorization. But a lot of things has changed under this administration. So applying for asylum right now is not as easy as it was back then. And I will get to some policy changes regarding asylum in a few minutes. Employment-based immigration, you can obtain a green card through an employer. However, please note that if you've overstayed your visa, you cannot. An employer cannot petition for you to adjust status because you've accrued unlawful presence. And unlawful presence is not waived through an employer. It's only waived if it's a family-based petition. A lot of people have been falling for the national interest waiver scam. Oh, I have all of these degrees and all of this. I'm able to apply for national interest waiver. That's just one part. The approval of your I-140 NIW does not mean that you can actually adjust status. It's just like filing the I-130, marriage-based, family-based. You get it approved, but that doesn't necessarily mean that you can adjust status. If you have some inadmissibility issue, you can have an I-130 approved, but the I-485 would be denied. And that's the same for the NIW. You can have the I-140 approved, But if you've overstayed your visa, the I-485 would be denied for unlawful presence. So technically, you've wasted your time, money, and effort to apply for something that does not really give you what you want, and which is the green card. So you have to be very careful. A lot of people have called my firm. Oh, somebody told me the NIW, I can apply for it. And after I screen them, I consult with them and I say, hey, yes, you are eligible for the national interest waiver. And some attorneys will tell you, go and bring $10,000, I'll do it for you. But they wouldn't tell you that after that NIW is approved, you cannot apply for I-485 because you've overstayed. So for you to be able to benefit and actually get a green card through the NIW process, you must remain in lawful status. You must remain in lawful status until the end of that entire process. If you're a student, you must continue going to school. If you're a visitor, you must continue being a visitor. You must remain in lawful status, basically. So please, you have to be careful. There's been a lot of scams going on, and I just wanted to point that out. Now, in terms of policy changes, now for all cases, there is going to be a mandatory interview. All cases, including VAWAs, green card, adjustment of status, would have to go through the interview process. A couple of months ago, we applied for marriage cases based on the evidence that we submit, and USCIS is like, all right, this is a very well prepared packet. We're going to approve this case with an interview, not under this administration. So it is very important that before you submit your case to USCIS, you hire an expert, a professional, to go through all of your evidence because you would be interviewed. And now the new cases are being processed faster. I would tell you that all of the cases, marriage cases, adjustment of status cases that I filed earlier this year, most of them has received your green card or interview dates. So the processing time right now is about 5 to 6 months for adjustment of status cases. They're working backwards. So if you file anything this year, you're most likely going to get an interview. If you file for asylum earlier this year, you probably would get an interview within a couple of months, even before the 150 days to apply for work authorization. So this is why it's very important that you hire a professional to look over your evidence and case before you submit. I understand legal services are not cheap. Attorneys charge thousands of dollars to assist you, but you're not only paying to fill out the form because that's what, oh, is it just to fill out the form? No, you're paying for their expertise. You're paying for the things that you as an ordinary immigrant would not see when you are looking at this evidence. One thing about me is when people bring pictures and bring bank statement, I sit down and look at this document and say, hey, we're not using this, we're using that. And they ask me why. Because if you claim that you're living together with your spouse and you have this bank accounts, I don't see any commingling of funds. Like I can tell from your bank statement, from your bank card, that only one person is running this account. And I'm seeing multiple Zales, multiple Venmo. That's a red flag. But people don't care. They just think, all right, let's open a bank account and that's it. Pictures. We have so many selfies. We have so many pictures together in the house. Somebody's washing dishes. Oh, we're hugging each other. What does that picture must tell a story. Why is this picture important? Why should I take a look at this picture? Is it an event? Is it a significant milestone? Is this the first time this lady will ever wash dishes in her life and I had to take a picture? It has to have a meaning behind it. It's not just let's go take a picture. Oh, they told us we need 20 pictures. All right, let's look for a different angle and take 20 pictures. No. So it's very important that you hire a professional to review everything you're submitting to USCIS. And besides that, under this administration now, there's now a fraud vetting unit for VAWA and asylum cases. So before they even decide to schedule you for an interview, they're going to send your application to that fraud unit to determine if it's fraudulent, if it's a fraudulent application. If it's a fraudulent application, then that's going to be a big problem. So now there are specific fraud vetting units for asylum and VAWA cases because there's been a lot of fraud being committed either by attorneys or by just individuals when it comes to filing for asylum and VAWAs. So be very careful of notarios, we call them, and these are paralegals. These are people that just advertise, we help with legal services. They are not a licensed attorney. They don't have any ethical obligations. They're just helping you fill out your form for $500. They don't have any liability. So if anything happened, you can't really say, oh, it was Mr. Jones that helped me, because Mr. Jones doesn't really exist. You cannot say, I didn't know what I signed. He just told me to sign. You have a duty to review everything you sign. And under the new policy changes, all cases that are denied now are automatically referred to removal proceedings. Unlike years ago, if you apply for a green card and the green card application gets denied, maybe you can refile again, you can wait, you can change, But now, any denial equals being placed in removal proceedings. Within 30 days, you're going to receive a notice to appear in court. So this is why it's very important to make sure that you are a professional. I know I keep emphasizing on that. Now, in terms of asylum, many of you may already know that you have to apply for asylum within a year of entering the US, unless certain exception applies. And that maybe you hired an attorney and the attorney didn't do their job, they didn't file their asylum, and this could be ineffective assistance of counsel. Maybe you were going through some kind of illness, mental illness, and just certain things you couldn't apply for asylum within the 1 year. It could be because you were under 18. Maybe you entered the country at the age of 15 and now you're 17 and you feel like you're in the right state of mind to apply for asylum. So there are exceptions, or maybe the country condition has changed. At the time you left your country, everything seemed fine, but now it's been 15 years and certain things have changed. Maybe at the time you left your country, you were under the LGBTQ, and now you're part of that community, and your country does not really like that community, and you would be in prison if you go back and the government finds out that you're part of a community. You can apply for asylum even 15, 20 years later, but you just have to demonstrate that certain things have changed since you left the country. 2023, the new policy about people who entered the United States without inspection. So if you cross the border, and I see a lot of Nigerians actually crossing the border now. So if you cross the border and you apply for asylum, starting May 10, 2023, you must, in addition to every other requirement, also demonstrate that you applied for asylum in every country that you traveled through and you were denied. Now, that's a big one. So if you're coming from Nigeria, for example, if you're coming from Nigeria, you cannot tell the US government that you didn't travel through any other countries. And I'm not talking about people who entered with a visa, very specific people who crossed the border. You must have traveled through El Salvador, Honduras, Brazil. If you cannot prove or show the US government that you attempted or you applied for asylum in all of these third countries before entering the US, then you're automatically barred from applying for asylum in the US. Imagine something is chasing me and I'm running. I see different doors open and I'm like, no, I don't want to enter this house because it's pink. My favorite color is blue. And you decide to run because you heard that there's this beautiful house 5 blocks away with a blue entrance, and you're like, well, my life is in danger, but I can still make it to that blue house. Then technically the US is saying your life is not in danger, because if your life is truly in danger, it would not matter the color. It would not matter the country. Now, if you can prove that you attempted to enter that pink house, but they pushed you outside, you attempted to enter the yellow house, they pushed you out, you had no choice than to run to the Blue House, that's different. Or you can show the exception that your life was in danger because when you peeped into these houses, something was going on and you were like, oh my God, I'm not going to be safe here. If you're unable to show all of these exceptions, then you are ineligible for asylum. And this is for people who entered after May 10 of 2023 without inspection. If you cannot show that you applied for asylum in third countries through en route to the US, you're ineligible for asylum. Also, new policy changes is the pre-termination laws. Specifically, if you're in immigration proceedings, the judge is now allowed to actually dismiss your asylum application just by looking at the I-589 application. So for most people who go to Notorious and they apply for asylum and they're like, oh, see my story, or I will submit my story later, or they just write 2 sentences of their story. Now the judge can look at the application and dismiss your case. And no, you cannot reapply. So just because the judge dismissed your case doesn't mean you can reapply. No. It's a pre-termination law. We're going to dismiss your case because it's legally insufficient. We're not even going to give you the opportunity to present any testimony or evidence because it's very clear that you don't have a claim. So they want you to submit a very well-detailed I-589 application. And you must know your story. You must know the information on your I-589. You signed the page 9. So no, it's not only because Mr. Jones assisted you with the application. You have a duty to review every legal document, every application that is being submitted to USCIS or the Immigration Court. And as we all know, that if your case is dismissed in proceedings now, it's an automatic ICE detention. And I will get to that shortly. I know a lot of people who filed for asylum and they say, hey, my asylum has been pending since 2017. My asylum has been pending since 2008. It's been 10 years. I'm just renewing my work permit. But that's not what I want. I want to get a green card. Well, the good news is you can file something called a writ of mandamus. A writ of mandamus is basically a legal action filed in federal court to compel USCIS to make a decision on your case. And so basically you file the writ of mandamus. They have 60 days to take an action. 60 days from when you serve them. So you file January 1st, you serve them January 5th of 2025. They have until March 5th of 2025 to make a decision, meaning schedule an interview. If an interview has been scheduled and you've attended the interview and you're just waiting for a decision, they have to approve or deny the case within that 60-day time frame. So these are for cases pending outside processing time. It could be for VAWA cases. And as we see, the VAWA processing time continue to change. About 2 years ago, it was about 24 months. And I believe now it's about 48 months. So every month, it seems like it's increasing, it's increasing, it's increasing. And now we have cases pending for 4 years, 5 years, VAWA cases. You can file a writ of mandamus if your VAWA case, your asylum case, your marriage case has been pending outside the normal processing time. And this cannot be used, filing a writ of mandamus cannot be used for cases in removal proceedings. So you know how sometimes like, oh, my final court date is in July 1st. Thank God now I can, the judge can hear my case. Maybe it's gonna grant me asylum or not. And then on June 25, you get this letter saying, oh, your new court date has been changed to 2028. 3 years. You're like, oh my God, what am I gonna do? Unfortunately, you cannot file a writ of mandamus for that. You're either going to try to write a motion to the judge and say, hey, come on. But most time, the judge is going to be like, well, there's nothing I can do. You're going to have to wait. And this is why you see a lot of people, their immigration case has been pending 10 years, 15 years, they've been in court, nothing. Right? And the sad part about this is some of your case can become mute, like your evidence. Because if you filed for asylum 10 years ago and 2025, 10 years later, you don't even have any claim anymore because the person you are afraid of is already dead or the country condition has changed. There are new laws. The judge is going to be like, oh, well, you said FGM. Oh, your country actually has a law that bans FGM now. So you're safe. You don't have to worry. And then they deny your asylum application. So unfortunately, you cannot file a writ of mandamus for cases in removal proceedings. And filing a writ of mandamus does not mean automatic approval of your case. So just because you file doesn't mean they have to automatically approve your case. They still have to go through your evidence and all of the things you submitted. If they have to schedule an interview, they have to schedule an interview. If they have to approve or deny the case, but they have to make a decision within the 60 days. They have to make a decision within the 60 days. A lot of people are also afraid that, suing the government, what's going to happen? Are they going to come after me? Are they going to deny my case? No, there are actually no legal consequences to you for filing a writ of mandamus. It's somewhat a right. You guys are delaying my case, I'm going to sue you. And most times, this writ of mandamus doesn't even go into trial. We settle. There's settlements like, all right, you know what? We'll talk to USCIS, we'll see what's going on with the case and blah, 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 things like that. So don't be afraid to sue if your case has been pending for so long, especially an asylum case, because if you wait for that long and things change, most likely your asylum case will be denied because you will no longer have a viable claim. All right, so it's very important to note that. In terms of immigration proceedings, a lot of people now, they're like, oh, I don't even know that I'm in court. I filed for I-485. I didn't receive anything. And then they said, oh, I had a court case that I never showed up. I didn't know that. Usually when they place you in proceedings, you're supposed to receive a notice to appear in court. And this is what a notice to appear looks like. This is what it looks like. Your name is going to be there. It's kind of like, I tell people, it's like the criminal charges in immigration law. They say, or you're a citizen of Nigeria, you enter the country. They're going to be like a bunch of charges here. They will list it like basically the crime you committed in violation of the immigration law and things like that. So everybody in removal proceedings should have a notice to appear. If you have one and you're unsure of how to see when is my next court date, I don't even know when my next court date is. I don't even understand this. You have to be familiar with this website. It's called the Automated Case Information, EOIR. The EOIR is going to tell you to enter your A number. I'm just going to use 0000 for now. And then with that, you'll be able to see when your next court date is, what the status of your date, the date, the time, your name, the location. And that's 100% accurate. This site is 100% accurate. Because sometimes it can be confusing. The NTA is going to show you have to show up July 1st, but this is also going to say, oh, you have to show up July 30th. Or your NTA will say, show up July 30th, and this is going to show you show up July 10th. Don't assume that the NTA is correct. Like, okay, no, this is wrong. I'm going to show up on the 30th because you will be ordered removed for failure to show up for your court hearing. So be familiar with this website. Even if you're not in proceedings, it doesn't hurt for you to randomly just check, like, okay, let me just put in my A number just to make sure that, I'm not in proceedings. Okay. I stated before, policy changes, all denied cases now equals referral to court. So your I-485 is denied, you're going to be placed in removal proceedings. Your asylum case is denied, you're going to be placed in removal proceedings. Now, if you're placed in removal proceedings, what are the possible reliefs that are available for you? We know that if you apply for asylum, you can continue with your asylum in court. If, for example, you're a green card holder and maybe you got stopped by the cops for DUI, you're so happy because something happened and you were driving DUI, you got arrested. Now you can be placed in removal proceedings and they'll try to take away that green card. You are eligible to apply for a cancellation of removal as a green card holder. That's a possible relief. If you do not have a green card, and everybody, please, it's very important for you to listen to this. If you do not have a green card and you're in proceedings because you went out with your friend and something happened, you don't have any case pending, right? You're just hiding. Hopefully one day God is going to do the magic and you be able to get married or do something. You got caught up in some things, and now you got arrested, you're placed in room of proceedings. What are the reliefs? If you're not eligible for asylum, but you've been in the country for at least 10 years, don't let attorneys sell this old 10-year green card to you. Like, oh, because you've been in the country for at least 10 years, you automatically get a green card. No. There's something called the cancellation of removal for non-permanent residents. We also call it the 42B. Yes, it's for people who's been in the country for at least 10 years, but it requires more. EOIR 42B requires that you must show that you've been a person of a good moral character, and you have to show that your deportation will cause an extreme and unusual hardship to your U.S. citizen child parents, to your U.S. citizen or green card holder spouse and parents, or children under the age of 21. And for that, you must demonstrate extreme and unusual hardship. So it's not like, oh, I'm a single mother, I'm a single father, nobody's gonna help me if nobody's gonna take care of my kids if I go back home. That is not considered extreme and unusual. But if you have an autistic child, if you have parents who are citizens and they have medical issues, and you are basically their caretaker, then that's extreme, and you have to provide a lot of evidences to demonstrate this extreme and unusual hardship. So do not let people sell you the 10-year green card thing, because a lot of people say, oh, there's something called the 10-year green card because I've been in the country for 10 years. Trust me, there are a lot of people who've been in this country for 30, 40 years. If it was that easy, a lot of them would be a green card holder. So be very careful. EOIR 42B, cancellation of removal, it's an available relief in immigration court. Asylum is an available relief. Unfortunately, voluntary departure is also an available relief. I know people don't want to hear this, but maybe it's time to pack the bags and leave. Maybe it's not worth the stress. And that's a relief in the U.S. immigration court, voluntary departure. You want to leave? We're going to give you a time, 30 days, 60-day grace period to leave the country. You can also adjust status in immigration court. If you have an approved I-130, an approved FAWA, and the judge is able to adjust your status in immigration court. Okay, as long as you are not inadmissible for any reasons. Now, I think I had mentioned this earlier before, that dismissal of proceedings under this administration equals ICE detention. Before, I used to dismiss a lot of immigration proceedings, and it was a good thing, right? You filed for asylum, your asylum case doesn't really have a good merit, it's not really a strong case. Rather than being ordered removed, getting the case denied, getting another deportation, I try to talk to the government attorney, like, hey, can we drop this case? Basically going back to square one. And they agree, and everybody's fine. But now, if you agree to dismissal of a proceedings, especially now that there's a pre-termination law, you don't even need to agree to dismissal of proceedings. If the judge decides that you don't have a good case and your case is dismissed, ICE agents will be waiting for you outside to grab you. And that's it. You're going to be detained. It's another order to get you released, because you have to go through the bond process. The judge can say, hey, he or she's a flight risk. I don't want all, now they have so much discretion, like they could do whatever they want to do. They can decide they don't want to release you because they just feel like it. And then you're going to be in detention for a long time. And this brings me back to expedited removal. Under under this new administration, if you've been in the United States for less than 2 years, you are subject to expedited removal. If ICE should arrest you, expedited removal means you don't have to go to the judge. You don't have to go through any hearing. They don't even need to see anything you have. They can just take you, detain you, put you on the plane, go back home. That's what it means. So if you've been in the country for less than 2 years, you are at risk of being expeditedly removed from the US if you don't have any status, without any hearing, without any trial. So I've been advising people that if you've been in the country for more than 2 years, you have to carry proof. Because of all of this ICE raids, you don't know what's going to happen, right? Birth certificate of your children. You have children born 3, 4, 5 years ago. Have a copy on your phone. Your taxes, your W-2. Just carry something that shows you've been in the country for more than 2 years. If you have an asylum case pending, I don't see reason why you should be going to the Nigerian embassy to renew your passport. You have an asylum case pending. You should not be going to your country's embassy to renew the passport. You are intentionally and purposefully availing yourself to the protection of your country if you continue to carry that country's passport. So you have no business carrying your Nigerian passport or any other passport with you if you're filing for asylum. And as we see on the news, ICE agents are now authorized to enter immigration courtrooms, waiting areas, lobbies, and and arrest people. So everybody's just got to be careful. Now, other policy updates. Now, there's a quota that ICE has to arrest at least 3,000 undocumented immigrants in a day. That's a lot, 3,000. And this is why they're grabbing people left and right, left and right, left and right, left and right. So please, if you don't have to be there, don't be there. You don't have to go somewhere. Just stay low key. Especially if you've been in the country for less than 2 years. And we see the old news about the travel ban. No, Nigeria has not been placed on a travel ban yet. There's a 60-day requirement for Nigeria to comply with certain things, which includes Nigeria open to accepting the deportees, because should Trump decide he has to deport certain Nigerians, Nigeria has to be willing to accept them back into the country. So we don't know what the fate is going to be, but we know that under Trump 1.0, there was a travel ban on Nigeria for a very long time. So 60 days, it's around sometime in July, August. We'll see if Nigeria complies with this requirements, or it's going to be subject to a ban, among other countries. They're also applying for a student visa. If you're a J1M visitor visa, now the requirement is that your social media accounts must be set to public settings. You cannot private your social media accounts. They want to see everything you're doing. So be careful what you post. And I'd say this to everyone, regardless of whether you're a student, you're applying for a student visa or whatnot. If you're be careful what you post. They are watching. They're monitoring your social media accounts, whether you're applying for a green card in the US, whether you're in the process, whether you have asylum case pending. Be careful what you post. Okay. For people who have a warrant, what can you do if ICE agent is at your door? I advise do not immediately open the door. Ask the agents who they are. Show their badge. They have to show their badge through the window, pass it under the door, but don't open the door. Just find a way to be able to see their ID. And then if you've confirmed that person is an ICE agent, then ask if such person the agent has a judicial warrant signed by a judge. If there's a warrant, tell them to slide it under your door. If it's a valid warrant, then you must open the door. Okay? You have rights to remain silent. And just tell them you want to talk to your attorney. You don't want to say anything. You have the right not to consent to a search. You don't want them searching your home, things like that. And this is what a judicial warrant looks like. I'm not sure if this is clear, but you can pull it up on Google. It's from the U.S. District Court, signed by a judge. There's specific dates, your specific address. So you have to make sure you're looking at this thing very carefully to, they want to go to number 21 and they mistakenly went to 22, but you didn't pay attention. And you let them into your home, and eventually they found out that you're undocumented, they arrested you, things like that. Well, you cannot say, well, your warrant had the wrong address. I didn't really realize that. You have a duty to make sure that you are looking at the document properly. Same, if an ICE agent comes to your workplace, they are allowed to enter a public space, such as a restaurant. So if you work at a supermarket as a cashier, then you may be at risk. They don't need a warrant for that. Any public space that anybody's allowed to enter, ICE can also enter without a warrant. Unless it's a private space, like an employee lunch area, like the back room, the employee space where only the employees have access to, then they need a special warrant to be able to enter such area. Okay? What do you do if you're detained? Remain silent until you contact a lawyer. You do not need to sign any documents or any questions. If your family member is detained and you are not sure how to locate that person, there's the ICE Locator website. Just Google like ICE detainee. You can just Google that, and that's the website. So once you do that, you enter the person's A number. When you enter the person's A number, the country of birth, and then you search. Or if you don't know the person's A number, you search by the person's first name, last name, the country of birth, and the date of birth, and you should be able to locate where that family member is. Okay? Because sometimes, like, you're unsure, your brother went to work and you haven't heard from him, and you heard that, ICE raided his workplace, you're not sure where he is. This is how you're able to locate that person. Okay, so it's locator.ice.gov. It's a very important tool. And can you record ICE during a raid? Yes, you can. You are able to legally film ICE. So if there's an ICE raid going on and you have some people around you, they can record. Or if you are the US citizen and there's an ICE raid going on, you can openly record. But of course, you cannot be in the face of the agents, like right in your face. If you're directed to back up, you have to do so, but you do not have to stop recording. Okay? ICE, they use different tactics to get into your home. They try to say, oh, I'm looking for somebody. Please, can you open the door? Oh, we're conducting an investigation. A crime just happened in your neighborhood and we want to make sure you're safe. Can you open the door? You please do not, because they use different tactics to come into your home. And basically that would be consent. So you can say, oh, because they lied, they told me they were investigating a crime in my neighborhood and that's why I opened the door. And now they asked me for my immigration papers, but I didn't consent to that. Well, you opened the door for them. So you basically consented to their entry. Okay. The Lake and Riley Act, this is a law that was passed under the Trump administration. Basically, it requires that the Homeland Security immigration to detain undocumented immigrants who have been arrested for burglary, theft, larceny, or any shoplifting, regardless of whether they've been charged or arrested or convicted. So if there's any arms that they think you shoplifted or you committed any act of burglary or theft, that would be automatic ICE detention. Advice: always carry a copy of your ID and receipts of any pending application. If you have a marriage case pending, if you have anything pending, just make a copy, put it in your bag, right? It doesn't hurt. If you've been living in the US for at least the last 2 years, make sure you show proof. If you are a US citizen, and people say, I'm a citizen, I don't have to carry anything, please, you have to carry something. Take a copy of your birth certificate, take a copy of your US passport, or, apply for the passport card. It's probably like $40 and just put it in your wallet, right? Because if ICE is raiding and you're there and they arrest you, they detain you, you're like, oh, I'm a US citizen, I'm a US citizen. You don't have any proof on you. So, they will still take you to an ICE detention. You probably will be there for like 2-3 days before they figure out, oh, this person is actually a US citizen. Please, avoid all of those drama. Do not enter public transit without paying the fare, right? The bus, I'm not sure how it works in Texas, but if the bus is $3 and you only have $2 on your Metro card, don't try to play smart with the bus driver or the train instructor. Like, you know what? I'll just tell them I have $2. Yeah, they'll let me go. Whatever, please, because they can actually detain you for that. And the most important thing that a lot of people don't want to hear and they don't like to hear is creating a plan. What happens if I'm detained? What happens if I'm deported? What's going to happen to my property? What's going to happen to my kids? Who's going to care for them? Who's going to undo my mortgage? Are they going to sell my house? Create a plan, because all of these people that are being arrested and being removed, it's not like they plan on being removed. Some people just went to work and the next thing they're in their country, just like that. So make sure you create an emergency plan in case something happens, especially if you have young children. Okay? Now I would open the floor for questions and answers.
Thank you so much, Attorney Aderibigbe. Wow, that was very informative. I mean, I
Thank
believe
you.
every one of us here had it all. It's good to always, be